Thank you all for attending today. Uh, Today, I will admit it, as you just got the preview, next month and the month after are probably the most interesting modules. This might be the most boring one, but it's also really important because today we're going to talk about the rules and regulations and directives governing the clearance process. It will be a bit of a slog, and I will promise to deal or explain kind of the catch-22 of clearances. Specifically, you need a clearance to get a job, and you need a clear job to get a clearance. So to date, we've talked about the cool places you can work, both inside and outside of government with a clearance. Talked about a broad overview of the clearance process, and we did take a deep dive into the start of the clearance process, the SF-86, again with that drug use, we're going to dedicate a whole module to. Do want to remind you about the Q&A box. Please don't put there, I'm here. You know, that one again, as Kendall noted, just contact her directly. But if you have any questions that come up during the talk today, just put it into that Q&A box and I'll try to get to it. The standard disclaimer, I am not a lawyer. I'm not giving legal advice. If you are in a situation that requires legal advice, go see a real lawyer for real advice. So where does basically the SF-86 come from? Where does the investigation come from? It's laws, it's executive orders, presidential directives, and regulations. The concept is that everyone is treated the same. And by the way, historically, it was not quite that way. If you came from the right family, went to the right schools, you got a clearance. If you didn't, you didn't. So a few decades ago, some set rules were created because there were also differences between different agencies. And the idea was to have clear rules. So, yep, I'm likely to get a clearance, or I should be able to get a clearance, or no, this really isn't for me. And that they're uniformly applied. Just because you went to the right school doesn't mean you get in. Just because you're a first generation American doesn't mean that you don't get in. And protected status cannot be used against you. For example, disabled veteran can't be used as a reason to not get a clearance. This cuts across agencies. An issue which honestly we are still working with is clearance portability. That if you get a clearance working for the Navy, that's good for the Army, which is good for the Department of Energy, which is good for the FAA. The idea is that, it's once and done. Once you are cleared, you should basically be cleared. The first level of clearances is what we call public trust. So this is not strictly a clearance for secret or top secret information, but basically, what does it mean to work for the government? So the government has these security requirements to be employed by the government, but we do couch it in terms of national security. So you notice we're not talking about people accessing secret information. We're just saying that you have the privilege to be employed by the federal government. And having the privilege to be employed by the federal government means that you need to be reliable, trustworthy, of good conduct and character, and of complete and unswerving loyalty to the United States. That's the baseline for any federal job. There was a court case about 70 years ago that said you don't need necessarily a background investigation for any government job. But if you're in a position that has heightened responsibility. Even a non-cleared role in the federal government would require this public trust investigation. So what do we mean by everyone is treated equally? Well, it's our tradition, and this is coming straight out of the Executive Order 10450. It is the American tradition that all people receive fair, impartial, and equitable treatment by the government. So again, and it's re-emphasizing the privilege of working for the federal government, uh, that we judge that or adjudicate by consistent and no less than minimum standards. So this means if you're kind of on the edge, but on the wrong side of the edge, you're over that line. But conversely, everyone has the same line. It's not uh, a further line for my nephew where we get nepotism from. And that the different departments and agencies have pretty much the same rules. Another part of that executive order is that everyone is investigated as appropriate. We're not going to say, oh, you're my friend, you don't really need an investigation. I know you're okay. No, everyone gets the same investigations. Uh, Now, one of the things they're looking at, and this is where we get, how deep are you going to get looked at? And I'll talk about this here and on the next one. But how much damage can you do in the nature of your role? One thing is, this is why we have the employment questions on the SF-86. You'll notice that there can be inquiries to law enforcement agencies, police records, former employers, employment records, and in fact, even talking to people at those, uh, whether it's an investigating police officer or your supervisor or your colleagues. This is the uh, authority for that. Again, it's detailed as needed. If you are in a position that needs a secret clearance because once in a while you might see a tiny bit of or exposed to secret data, is probably going to be a different level of investigation than someone who is dealing with data that could bring catastrophic impact to the United States if that information is leaked. Uh, and so this is where, uh, you know, uh, we check your credit, we check your work history versus the FBI coming out, knocking on doors, talking to your neighbors, talking to your friends, talking to your friends' friends. The idea is that the investigation is as detailed as it is needed. So one thing you can get, and judging from the questions, some of you may have already experienced this, getting an interim clearance. And so it's basically two things are going on here, which is, you don't have any big red flags of felony convictions. You're in a lot of debt, issues like that. So, the agency believes you are going to likely to get cleared. Then the head of the department or agency, if they need that role filled, can basically suggest that it's in the national interest for you to get an interim clearance. I do know that it's rare, but it does sometimes happen where someone has an interim clearance, they go through the full background investigation, and their clearance is denied. That is, it's a remote but not unheard of possibility. This is another thing, again, we've talked about before, but to re-highlight, it's not once and done. It's continuous scrutiny that if they find out, if you get arrested and you don't report that, it's going to get found out. If you stop paying your bills, it's going to get found out. If you all of a sudden have a lot of money, it's going to be found out. And any of those things can cause a review or re-adjudication, meaning they're going to do basically another full background investigation, and you can lose your clearance. So, be aware of that. And then the last thing in the executive order is basically saying, stay good. That you can have your interim clearance suspended, you can have a full clearance suspended. So it's not just, oh, we think you did something bad, we'll do an investigation and then pull your clearance. No, and if you think about it, it makes sense. If there's a reason to question your uh, trustworthiness and ability to hold a clearance, your clearance will be immediately suspended while they're doing the investigation to figure out whether you can still keep your clearance. And by the way, for many roles, given that you need a job to have the clearance, you need the clearance to have the job. Well, if you don't have that clearance, you're probably not legally qualified for that job. So your employment can be terminated. Uh, Again, when we get into details, uh, if you have been arrested and you tell your agency right away and you've had a kind of a good adjudication from that, um, that will be taken into account. I got a good question there, but I'm going to hold on to it. So there are explicit guidelines. Remember, the government has said we want everyone to follow the same rules. Now, this executive order is from a couple of decades ago. So things like behavior, activity, or associations that show you're not reliable. If there's a lot of drunken, disorderly conduct, if there's gambling, if you're hanging out with known terrorists, that's like Section 1I. If you've lied or omitted anything on any of your forms, that's saying you're probably not trustworthy. It's an explicit guideline. Any criminal, infamous, so again, we're using decades old language, dishonest, immoral, or notoriously disgraceful conduct, habitual use of intoxicants to excess, drug addiction, and it does say in this executive order sexual perversion. The perversion clause itself is not a criteria in itself, but bad behavior still is. If you're abusing people, non-consensual things, that's showing that you're possibly not trustworthy. Uh, Here's one that, a lot of people ask about, any illness, including any mental condition of a nature which, in the opinion of competent medical authority, may cause significant defect in the judgment or reliability of the employee. So they're not looking, oh, uh, you have multiple sclerosis, you can't get around well, obviously you're not trustworthy. No, that would not be something that would disqualify you. However, if you have psychosis, you have trouble distinguishing between reality and fantasy, that would be something that could result in a defective judgment. And so again, competent medical authority, not I heard that this person has psychosis, but you have a diagnosis of psychosis. That would be a guideline that you would not be eligible for a clearance. And then there is kind of a catch-all, which is if there's some situation that gives a reasonable person the belief that you would be subject to coercion, influence, or pressure. and again, decades old, cause him to act contrary. Obviously, this is for anyone acting contrary to the interests of national security. And this is why we look for things like debt, because if you have big debt, then who you owe money to might be able to coerce you to violate the trust of the United States. Uh, Number two, it's almost like, why do they say this? Well, set rules, but if you're actively harming the United States, not a surprise we don't trust you to protect the integrity of the United States. Number three, continuing association with, spies, seditionists, anarchists. If you're part of the let's violently overthrow the United States club, which is actually number four, but if you're in that club, you're not doing it, but you're associating with that club, probably not trustworthy. And especially, if you are in fact advocating for the violent overthrow of the government, uh, then we're not going to consider you to be trustworthy to hold a clearance. Note that in paragraph four, which unlawfully advocates. So this is not a limitation on your First Amendment rights. Um, but the First Amendment gives you the right of free speech, but it does not give you the right to advocate for the violent overthrow of the United States, or does not give you the right to advocate for terrorism and the harming of United States people. So with these basic, and again, these are kind of foundational guidelines, the advice I would give is don't be stupid. So if you intentionally, without authorization, disclose security information, you're out. Or willful violation, which would be Snowden, person on the left, uh, and also willful violation, Chelsea Manning, or Bradley Manning at the time of the picture on the right, or blatant disregard of security regulations. That's Jack Teixeira down in the middle there. Don't be them. You notice all of them are, well, two of them are arrested. One is living the high life in Russia. It gets very cold in Russia. Would not advise it. So, I was talking about public trust. Now let's get into classified information. And what do we mean by classified information? There are three levels of classification: confidential, secret, and top secret. Confidential is kind of like a foul in soccer football. You're breaking the rules, which a reasonable person would expect could cause damage to national security. Secret is the yellow card that that would be serious damage to national security, and top secret is the red card. These are things that, if disclosed, could be expected to cause exceptionally grave damage to the national security. Uh, Notice there's no mention in here of may cause embarrassment to the agency. That is not damage to the national security. So something like that would be something that should not be classified. This is talking about things that would cause actual damage, serious damage, or exceptionally grave damage. Now, you might see, and quite often you'll see advertised, this position requires TS/SCI. And so SCI is sensitive compartmented information. This is top secret information. So exceptionally grave damage if it's let out. In fact, it's so sensitive that we really want to emphasize the need to know, and I'm going to talk about need to know in a bit, but the idea is that even with a top secret clearance, you need to be what we call read in. You need to understand what is sensitive, what not to divulge, who you're allowed to talk to, and all that. There are special access programs very similar to SCI. Probably the most confusing classification uh, is an unclassified level. It's called Controlled Unclassified Information, or CUI. Roughly used to be what was called for official use only. And somebody just put in, hey, is that for official use only? And the answer is yes. But the reason why I have the question mark on the yes is for official use only was kind of very nebulous. What did that mean? So for CUI, about 15 years ago, came out with a whole guide to what CUI is. There are well over 100 different kinds of information that could be considered CUI. The easy ones are things like personally identifiable information. Clearly, uh, if my social security number got out, that would cause damage to me, but it probably would not cause damage to the national security. But yet it needs to be controlled. So that's something that would be like controlled, unclassified information. And the thing that trips people up is it's unclassified. So it's kind of wrapping your brain about, well, who can see it, who can't see it, under what circumstances. Executive Order 13556 explains a lot of that. Obviously, there's unclassified information. If you look on the right-hand side, that's the cover sheet for the National Intelligence Classification Guide, where these definitions come from. That document is unclassified. You'll also notice it's got a little redactions in it, but with the redactions, it's unclassified. DOE has different access authorizations, Q and L. If you remember the Oppenheimer movie where he was waiting for his Q clearance, that is the rough equivalent to top secret. L clearance is rough equivalent to secret. So you've got a clearance, you've got your secret clearance. Does that mean you can see all secret stuff? And the answer is no. So step one, are you eligible for access? So that's the clearance is, are you trustworthy enough and have we done enough of an investigation for you to see secret information? Have you had the kind of full investigation? Can you see top secret information? So that's number one on this slide. Number two slide, though, on this slide, though, is that you have a demonstrated need to know. Just because you have a clearance does not mean you get access to information. In fact, if you're working in a department and you have a work colleague who's not working on your project and they start asking you about your project, that's a thing to report to your boss, report to your facility security officer, because unless they have a demonstrated need to know, they should know not even to be asking about it. But that's not it. There's also signing the non-disclosure agreement. Your agreement with the United States, even if you're just working for the federal government for 1 year, is for life. Uh, it doesn't matter that something happened, you worked on something 10 years ago, you still can't talk about it until, of course, that information is declassified. And there's regular declassification of information. But until the government declassifies it, you are still bound forever with criminal jail time, prison time penalties uh, to keep that information uh, private. Uh, Executive Order 12968 is the executive order that says government's going to keep looking at you. In fact, they did make a change just a few years ago. You used to have to leave your credit report unlocked so that the government could basically pull it periodically. Now I think the law got passed, so you can have your credit report locked so someone can't just open up credit cards in your name, but the government is still monitoring your credit report. Uh, and that access here, we're going to keep looking at you for 3 years. So if you're working at an agency, and then a hostile government buys you and you quit, and then you give the hostile government all of your secret information that you've learned, you're still in a boatload of trouble. So they're monitoring you because they'll say, oh, wait, look, you quit, and then all of a sudden you got $1 million in your bank account. What's going on there? Uh, Again, that 3 years is not, that doesn't mean 3 years later you can give them the secrets. That's forever. Uh, the other is you still have to report your foreign travel, even if you have left the government. And how do they do that? They get the manifests from the airlines. They get the border crossings from Customs and Border Protection. So just declare. Financial disclosure. Again, uh, you have given a disclosure report. I have some of my work has been financed by foreign government. I declare that. It's not that I can't take that foreign government money, but I have to declare it. And of course, if the government says, whoa, you can't do that, then I have to go tell that government, sorry, I can't do work for you. That's in my job as professor. Clearly, if you're working in the intelligence community, DoD, federal government, I really hope you're not taking any money from any foreign government. Uh, there could be, depending when I worked at the FCC every year, in fact, actually in the White House too, every year did annual financial disclosures. And by the way, one of the things they're looking for there is if you buy a bunch of stock in a company, and by a bunch, I'm talking about more than $5,000 worth, you need to report that. So one thing they're looking at is, did you report it? You know, wow, this says you bought stuff in February. Here it is December. You're only now reporting it. They're looking at trustworthiness there. It's not that you can't buy stock or sell stock. They just you need to report it. And likewise, the foreign travel. Uh, Here's the reciprocity section. Very important that you get a clearance, and as many of you who are going through the process and are saying it's taken months and months and years, the federal government doesn't want you to go through that again. We need cleared personnel. So this is establishing the concept of reciprocity. Now, clearly, if you've been working for one agency and another agency, say it's the FBI, and they get everything, and they actually happen to know, yeah, you really shouldn't have a clearance unless there's some information like that. Basically, once you have a clearance, you have a clearance. Uh, and the other thing is some agencies, for example, some agencies require a polygraph test. Other agencies don't. So that's an additional requirement. So like if you've not had a poly, going to a job that does require it, they're allowed to say, well, even though you got a TSSCI, you're going to go get strapped to a table and do the poly. So it's additional, but they can't just go do your whole investigation again because you've already been investigated. Uh, Again, this is foreign nationals. This is where I said it's very, very unlikely, but it is possible for a foreign national to get a clearance, but it's got to be special expertise. You are the only biologist on the planet who can understand COVID, and you happen to be a Swiss national. That would be very special expertise, very compelling reason, and you have the need for access. But even then, the government needs to be able to do a full 10 years or more of your life investigated deeply. Uh, and just to highlight it again, really, this is available to United States citizens. Naturalized citizens are fine. I know many people with clearances who are naturalized citizens, but they are citizens. Another part of this, and this is, you might recall, I called Executive Order 10450 your grandfather's executive order, talking about sexual perversion, talking about men. Here we're reiterating we do not discriminate on the basis of race, color, religion, sex, national origin, disability, or sexual orientation. Do you have the little star there? There is Executive Order 14168. There's been no change to 12968, but this is all said with an understanding that currently Executive Order 14168 is in force. So, here, sexual orientation, D, is not the sole issue, but that can be used as a wedge to do a further investigation. Here's a very important one. Um, Again, if you're suffering from psychosis, probably not going to be an issue. Uh, your mother was violently killed 20 years ago, and you went to counseling and you're fine. You had severe depression then, you're fine today. That is not going to be a reason to deny you a clearance. In fact, the fact that you went and got counseling is going to be seen as a positive factor. Hey, if you have trouble, you seek help. Yeah, you're more trustworthy as opposed to you had mental problems and you didn't try to address them, maybe less trustworthy. Um, and again, it's focusing on what are the requirements of the job. If you have a mental health issue or a physical health issue that has nothing to do, it's unrelated to your job, wouldn't impact your job, then that would not be allowed as a criteria to deny you a clearance. Uh, so uh, this is a thing that I do want to emphasize. You've gotten your clearance, you've worked at DoD for 4 years, and then you worked at a contractor for 3 years, and then you went off and did something else. If you go off and do something else, then you don't need a clearance, which means, and there is a period of time because we hope you'll come back. But after that period of time, you don't get to keep your clearance. Then on your resume, you would say, basically like, you're confident you could be cleared because you held a clearance, but and that you don't have it because you changed jobs, not you don't have it because it was denied. Uh, If you are denied a clearance, there is, and it's an admittedly a Byzantine process for protests. We have had speakers on this, like last year's clearance prep class, who did have successful outcome from a protest. I also know of people who had an unsuccessful outcome from protest. So if you are denied, you can ask for another look. But it's kind of it really depends on the facts and circumstances. If they misunderstood something, if they miscoded something, if they misunderstood something, great. If you don't agree with them that your drunken disorderly conduct 4 times uh, is a basis to be denied, you're probably still going to be denied. And there's Security Executive Agent Directive number 9, again, goes over these determinations. Uh, which brings us to talk about the seeds. So these are documents created by the security executive. That's the head of, that's the National Director of Intelligence, the head of ODNI. And that office is responsible for creating these directives to create these kind of standardized criteria for clearances. Uh, so where do the questions on the SF-86 come from? Seed 4. Because they're looking at these guidelines, and I'm going to dive into a few of these guidelines in more detail. But if you look at this list, do you have an allegiance to the United States and an unwavering allegiance? If the answer is no, then why are we here? Are you subject to foreign influence? Do you really like the way things are going in Russia? Uh, you really think the Chinese Communist Party, their system of government is better than our system of government, then, we're going to say, yeah, you're probably not uh, appropriate for a clearance. Uh, let's look at personal text, personal conduct. So again, this is not the text. The next ones I'll have some of the text, but this is kind of representative of the philosophy. Again, if you are going to hide facts or lie about facts on your SF-86 or when you have an interview or your resume, that's kind of showing your personal conduct is not entirely honest, which brings into question your trustworthiness. Uh, or by the way, the death by 1,000 cuts. Uh, if you had a drunken disorderly arrest when you were over 18 in college, that was charges dropped. And then a few years later, you had a minor assault charge that was dropped. And a few years later, there was, disorderly conduct that was dropped. If there's this drumbeat going on there, again, if you were just had like one of those, they're, like the college one, they'll say, yeah, college kids do stupid stuff. That's not enough to deny your clearance. But if there is this uh, collection of facts that when you consider the whole thing together, this person doesn't look trustworthy, that is enough to not get a clearance. Likewise, if your family is in the drug business and you're in the family business, uh, you're not going to get a clearance. So the flip side is if your family's in the drug business and you've moved across the country and you have no contact with them, you're totally estranged, you probably are going to be able to get a clearance. So it's the association that they're looking for. But we're talking about these issues, but there is the other side of the coin, the mitigations. So let's say you forgot something on your SF-86. If you go to your facility security officer, say, hey, I made this mistake. They can start the process. When you have your interview, the first thing they're going to ask is there anything you want to tell us from your SF-86? And you immediately say, yeah, and I went to my facility security officer. I'm sorry, I forgot I lived at this place, or I forgot I had this foreign property. If it's, I forgot I was arrested and put in prison, that's going to be kind of a question. But if you make prompt, good faith efforts to correct the omission, that's great. Uh, you know, you do have a requirement to cooperate, but also notice if it was your legal counsel that told you not to cooperate, that's a mitigation. Um, because you do have this presumption you must cooperate. Uh, but if your lawyer says, yeah, don't answer that, uh, and you've done everything, you've answered all the other questions, that's considered a mitigation because it's not that you decided not to cooperate, it's that your legal counsel uh, advised you not to cooperate. And again, kind of like the drunken disorderly when you were a kid, if it's a minor offense, or even like, say, drug use, but it's so far in the past, uh, and like it's unlikely to recur, then hey, that's a mitigation. Yeah, you made a mistake, but you dealt with it. Uh, Likewise, D, that's like addiction issues, because you do get asked, do you have issues with alcohol? Do you have issues with drugs? Well, if it's like, yeah, you know, 5 years ago I had real trouble with alcohol use. I went into rehab. I have counseling. I'm still going to my uh, support group. Haven't drunk anything for 3 years. They're going to say, all right, personal conduct, bad, had alcohol abuse issues, but mitigated by the counseling and again, kind of C, unlikely to recur. You're demonstrating that, then that's a mitigation. You could still get your uh, clearance. Again, next one is kind of like family business thing, or you used to be maybe not in a gang, but a lot of your friends were in the gang. Well, if you've like positively said, I've uh, uh, put that out of my life, that's a mitigation. Of course, if they have one report of you doing something really bad and that person is known unreliable, and you've got a whole bunch of other people saying, no, he never did that, then it's an unsubstantiated uh, assertion. And so, mitigation is they will look at where do they find that information from. And then another is like you had no idea that your roommate was a terrorist. They're a spy. They're a good spy. They're such a good spy. You had no idea. Well, we're not going to hold that against you. You're not the FBI counterintelligence unit. Uh, what will be considered is if you're told that and you say, yeah, but I like the rent, uh, you've lost your mitigation. So one question is, how do investigators handle forgetfulness? So this is, again, the unintentional falsification. Well, they are going to be looking at mitigation A. Did you make a prompt, good faith effort to correct it? Uh, what you don't want to have happen, I was talking to someone 2 weeks ago. worked for the FBI. So the FBI has some of the highest standards. Uh, and they got stopped in a traffic stop, and the officer saw that they had uh, appropriate ID. And so the officer said, yeah, I'm not going to write a ticket. Don't worry about it. And then they didn't worry about it. Well, the thing is, nowadays, when you get stopped by the police, the first thing they do is put in your license plate number because they want to know, is this a fugitive, armed, and dangerous individual? They need to know how they're going to approach the car, which means it's in the database. Your car has been stopped. That will get picked up. And so the investigator, by the way, when you're in for your annual review, or maybe it's for your first pass, they're going to say, is there anything you haven't told us? And you'll say, yeah, no, I've answered everything. And they say, well, what about this traffic stop, on March 3rd, 2024? And then you'll be like, oh, yeah, I remember that. I got off. It's like, why didn't you report that? Well, if that's the only thing, that is kind of mitigation C. It's minor, it's infrequent. Okay. The investigator, and by the way, it's the investigator's judgment at this point. Because if you forgot the 4 times you were stopped and didn't get a ticket, that's not going to look good. But no, that's a good question. Social media. So, on the one hand, the government can monitor and archive any of your publicly visible social media. So if you on X tweet, I want to overthrow the government with my AK-47, and then you delete it, doesn't matter. It's been out there, it's publicly visible. However, Seed 5 does explicitly say that the investigators can't say, oh, you're on Facebook and it's a private account, so give us your password so we can review what you've done. If consider that a test, report that to your FSO. Just say, I'm sorry, I can't give that to you, and then report it because they're not supposed to. If they say, show us your non-public posts, again, they're not allowed to ask it. Maybe if you're interviewing to be a counterintelligence FBI agent, again, they're testing you to see A, if you know that you don't give it up, and B, that you'll report it. Likewise, again, I'll use the Facebook example. You can have a profile that's private to your friends. The investigator, the agency, they're not allowed to say, well, make us your friend. We're not asking you for your password or showing your non-public, just make us your friend. Not allowed to do that. We are going to do a deep dive on social media in the social media module. How long is your clearance active? So remember, continuous evaluation. The government will be continuously, all the time, monitoring your credit report, your arrest records, your financial transactions, looking for suspicious activity. And that might trigger further investigation. And we still have periodic reinvestigation every 5 years for top secret, 10 years for secret, and 15 years for positions of trust, because things happen. Life happens. And also it kind of can work to your benefit as well, because there are a number of things that have you in the past 7 years or have you in the past 10 years. Clearly, like for your secret reinvestigation, those have you in the past 10 years will have rolled off. And so, by the way, what can happen is you don't need a full investigation. If they look at your SF-86, it balances out with your credit reports and financial transactions, employment history. It's like, okay, you filed it. Yep, you're good for another 10 years. Uh, and again, in a reminder, 12968 Part 5. If you don't need a clearance, you don't get to keep your clearance. Now, did get a good question here, which is it helpful to have misdemeanors expunged, or does the fact that it was ever on your record make the expungement just to make yourself feel better? Um, the answer is yes and a hard no. The hard no part is the SF-86 asks, have you ever been arrested? Is a question. A separate question is, have you ever been convicted? So the fact that whatever happened happened is a part of your record. Now, the reason why I didn't just say no, it doesn't matter, is having it expunged is a mitigating circumstance. So to say, yeah, when I was young, I did something stupid. I did some vandalism. Uh, I paid the fine, and after 2 years, the court expunged it, and I've been clean since. That, yes, I was arrested. Yes, I was convicted. Yes, it was expunged. You're doing the mitigation story for the investigator, so they don't have to figure it out. Because if you just say it was expunged, it didn't happen, well, you've lied on the arrest part. Uh, if you just say, yeah, I was arrested and convicted, then it's like, well, then why are we giving you a clearance? Well, because it was expunged 10 years ago. So definitely uh, do mention it. Do mention that it was expunged if it was. If you're wondering, is it worth it, the $3,000 in legal fees? Depends on what you're applying for. It just might be because either you have the court say, yeah, you're beyond it, you're reformed, or it was in error, it's gone. Or you have the investigator try to make that determination. And even though I've spent this whole time saying everyone's treated even equally, the investigator looks at all that stuff, no one wants to be the investigator who cleared Edward Snowden. So if there's any questionable stuff on there, it's so much easier for them to say no than to really consider the facts. So if you have independent people consider the facts, that is probably in uh, your investigation. So here is the catch 22. You need a clearance to get a cleared job, but you can only get a clearance by having a cleared job. Uh, so there are temporary clearances. Basically, the agency takes a quick look at your SF-86. There aren't any big flags. They do check to make sure you really are a citizen. They will do the FBI basically quick check. Are your fingerprints in the database? Is your name in the database? They'll check with the NCIC. If that all comes up and they have started the investigation, then you can get a temporary clearance. But the reality is, even for that, you could be weeks or months in a waiting pattern. One of the questions is, someone's got their interim clearance, but they still don't actually have a start date. And they're considering another job that might not be cleared. So the question is, will the investigation continue on and will you still get a full clearance? Let me give a scenario, a real scenario from one of my students, and we'll see if this is getting at your question. Uh, they had a cyber core scholarship, which meant they were required to have a government job. Um, and it happened that the one she wanted required a clearance. Uh, and they said, yep, we really want you. Here's your preliminary job offer, contingent on your getting the clearance. And they started the process. And she's waiting and waiting and waiting. And she's like, I've got to eat. Uh, what drove us nuts was So she went and she got a bartending job. Uh, what drove us nuts is there's actually a clock on Cybercore because she did have a non-cleared offer, and we were like, take the uncleared offer because it starts the clock, but you keep the application going, and then yeah, you quit and go to the other one. She did the bartending thing, very much an uncleared job, and then eventually, after a year, she got her clearance, she got her dream job. So on the one hand, existence proof that you can go take that other job because you need to eat. Talk to your facilities security officer first. Find out if that fits your situation. This goes back to caveat emptor. Get real advice from a real lawyer. In this case, get real advice from a real facility security officer who knows the requirements of your position that you're applying for. And so, for example, they may say, you want to be a bartender? Hell no. Or they may say, yeah, that's great, whatever. So I hope that answered the question. Question here is, are polygraph results used to factor in your security clearance or suitability? How are they used? Uh, I it again, it's kind of like the last answer. Very much depends on your agency, what they're going to do with it. I personally know someone who had a kind of perfectly clean SF-86, failed their poly, lost their job, appealed because they really did have the clean SF-86, lost the appeal. I know another person who always failed their poly, and it got to the point where that agency just knew that they were going to fail the poly, but digging deep into the things that the polygraph was unclear about always came up clean. So again, talk to the facility security officer of the agency that you're applying to. They'll be able to tell you their guidance. So in the last minute, uh, this is the schedule for the rest of the year. Again, another uh, 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 really interesting one for a lot of people is the deep dive. Believe it or not, cybersecurity authorities' laws and regulations will be very relevant to all of you going into cybersecurity related roles. The title looks boring, not nearly as boring as today. And then the deep dive into social media. And then we have a number of industry and federal speakers. Noticing the underlines. So we usually meet at 1 o'clock. The June and July sessions are at noon, and October session is at noon. And there is a change in the schedule. We had a federal speaker coming in on September 3rd. That will now be on September 10th. So that is the end of my talk. That's also right now looks like the end of questions. Last chance for a last question. If you do have another question, think of it later. Keep it for the next session. Kendall, I will happily hand it back over to you.
Thank you, Eric. Just to be respectful of time, we are done for the day. Appreciate everybody participating, and we will see you next time. Thank you.
Thanks.